Thank you very much. If you could keep your voices up too as well, that would be awesome.
The first thing, and I have a couple of agendas to be pretty soon. The first thing, though, that comes to the top is Judge Williams asked for a schedule for the Hunter Brown case.
Okay.
So where are we on that? Who represents Hunter Brown? Is that you, Will? I couldn't remember if that was you there. Where are we on the discovery for that?
The same
I know a lot comes in on that case.
We're pretty much in the same spot in all the other cases except on Wardson and Gallagher. Plaintiffs have disclosed all their fact sheets. Coordinated discovery applies the same to all the plaintiffs. The defendants haven't taken any plaintiff depositions in cases that don't have a trial date or scheduling order.
How many plaintiffs are in the Hunter Brown?
Five. I'm thinking five off the top of my head.
So that's manageable. What discovery do the plaintiffs need? I mean, Judge Williams specifically asked that we put some kind of a schedule together.
Defendants really need to take the plaintiff's depots and then the case is ready to go.
Case specific, causation, all the experts are pretty much being disclosed in the other cases. They're going to be the same or similar.
What's in Dealwater mean?
Same thing as the other cases. Are we trying to get a trial date and work backwards from there?
I don't know. I just got a message from his department that they wanted a schedule in that case. Probably because he does want to say. I didn't ask him.
I mean, I have all the trial dates in front of me.
Does Hunter Brown have one?
Yeah.
No, I don't think we do.
Well, that's probably why.
Although I think there's someone over 70 in that case, so I think we're entitled to an expedited trial date when we ask for one.
Well, let me ask you this. When do you think you can conclude discovery of the Hunter Brown case?
We're in trial till December. We're not in trial. Or when you said you meant the royal you, as in people in my office.
As in, yes,
The rest of us will be in trial.
yes.
Well, if we're looking at trying to expedite that one, then we better get it done in 90 days to get the plaintiff's deposition signed. I don't know where we are on medical records. You kind of hit me out of the blue on that one. I have to research it for a minute and see where we are on collecting medical records.
Your collection or our production? 'Cause I know we produced that.
Yeah, I'm sure we have your stuff. I just don't know if we've
Unfortunately,
had a need for
five
third parties.
plaintiffs.
Yeah, assuming we have a need to get subpoenas out for those records, shooting from the hip, we could probably take the plaintiff's deposition sometime this year and then do expert disclosures, whenever we have to, probably towards the end of the year. So to answer the magic question, can we get it done in 180 days? No. Can we get it
I thought you said 90.
I'm sorry about the expedited trial motion that apparently is going to come.
If it helps, we could agree to double track the plaintiff's depositions 2 a day, because the depositions.
So there's only 5 of them, right?
No, the depositions have only been an hour long, so
Yeah, they won't take long. It's just a question if we have the stuff we
Yeah.
need and
we
whether
could
or
do
not.
2 a day if you want.
We've got to depose the carrier plaintiffs, the sheriff plaintiffs, the Wren plaintiffs.
We apparently have a court reporter who's too polite. When they cut each other off, you need to let them know you can't get 2 people at the same time.
Thank
I
you.
can interrupt. But if we need you to have a good record, even though we're videoing this, so if you need one of us to stop for you to catch up, would you let us know?
Yes.
You're in charge of that.
Thank you very much. If you could keep your voices up too as well, that would be awesome.
So,
Since that wasn't on the agenda, if you give me a second, I will look it up and,
or let me know.
yeah.
No, I just found out yesterday. I don't know if you heard from their department or what. We have trials. Gallagher, then Watson and Carrier.
then Rick, those are all pretty much back to back.
What is the status of Gallagher right now?
Day 6 of the motion limited hearing today, or day 5. And,
You're still doing the motions.
yeah, we go back in tomorrow at 1:15, and Wednesday, Thursday, Friday. So I don't think we're getting done with motion eliminations this week. I'll be surprised. But certainly if we had a whole week next week, I think we can get that done.
Yeah, I agree.
Well, you want to guess at 6 months, and then you can let me know.
I'd like to look and see when the other cases have extra disclosures. It's, putting a square peg in the round hole, and we do literally have Hanwardson coming up, Carrier, Sharapov.
I'm
Wren.
sorry, can you say the name slower?
Hanwardson,
HUMWARDSEN.
Thank you.
Carrier, just like it sounds. Sharapov, SHARAPOV,
What about Martinez?
Wren, and then Martinez. All those cases are set between January 16th and February 5th. Most of them are on February 5th, although there's a stipulation to continue Martinez and one of the other ones.
And Brett, we just withdrew.
What's that?
In that case, we withdrew his counsel from. I think they sent request for admissions to him. He's currently incarcerated, as I understand it. So I think at least
That's my lead case.
Yeah, well, you might need a new lead steer on that one.
That's just Rick, you still have the other plaintiffs.
I think there's only 3 other plaintiffs in the case. It's not big.
Is it Wren set?
We're talking about two different cases. This is Rick, not Wren.
Oh, RIC.
I was talking about Rec.
Oh, yeah. That's RICHT, right?
Right.
Thank you.
That's the one you withdrew from?
Right. Ren's consolidated with Carrier now, so same case.
Bottom line is I would propose the parties meet and come up with a schedule for Brown. And if we
That'd
can't
be
agree, we
perfect.
submit it to you.
Whatever the, and I wasn't given a deadline. Just asked to kick out the schedule. And so why don't you try to get together on that and give me your proposed schedule? But did you see the email I sent to on that Rambula case?
Yeah, if we could save that to the end. That probably makes sense.
I think what you and I and that attorney just said it was set a separate telephone conference. He would, to catch you all up, the attorney for, I'm not quite sure how you pronounce it, Arundela, wasn't available today. And it just got consolidated in.
Right, yes.
So I told him this hearing was set with lots of parties and lots of attorneys, and that's why we couldn't accommodate even move the hearing. But I told him I'd set up a telephone conference with him and with Joel.
Who's plaintiff's counsel on that?
Gustav. Ponce. Gonzalo Ponce.
Who's he with?
Kazarini Loft Dodrill.
I don't think I brought those emails.
Kazerouni. Yeah.
I didn't bring that email chain in.
That was an unfair trade practices fine.
So as I said in the email, I'll put together a copy, just telephone copies of the 3 of us. I kind of explained to him, the case being coordinated with hundreds of plaintiffs.
Is it an injury case?
No, it is not. Only alleged unfair trade practices fines.
Was there stipulation?
To set aside the bankruptcy? Yes.
What kind of business plaintiff?
Sorry, what
Plaintiff's a business or something?
They are suing an alleged purported class action for all victims of real water who were deceived by unfair trade practices.
Which part is that? What
That's
judge?
from Judge Eller, I believe.
Now, I extended the expert discovery on Wardson, Wren, and Carrier, the expert discovery to July 17th for plaintiff experts, September 15th for defense, and September 29th for rebuttal. Are any of those scheduled, or has anything been done on that?
I think the July date got moved.
Yeah, we
It's
moved it
9/15 for everybody, right?
September 15th for all those is the deadline. So all the Hun-Wardson case is next up for trial, January 16th with Judge Kitchener. All the expert disclosures, initial disclosures are due September 15th. All the Hun-Wardson plaintiffs have been deposed. So the next thing is expert disclosures in that case. As far as I know, everything's on track.
Well, I was asked to extend, this is the date of this order. And obviously, whatever the parties agree to, it's probably going to be fine with me. It goes back to the end of June, about a month ago. And I had that the expert discovery for plaintiff experts would be September 15. Like I said, defense was, I'm sorry, July 17th for plaintiff, September 15th for defense, and September 29 for rebuttal. But whatever, if the parties agree to something else, that's fine. Hey, what did you agree to?
Yeah, it's simultaneous disclosures. We agreed to September 15th. And I think there was a couple corrected orders based on that. So initial experts, simultaneous disclosures, all
Oh, so
parties.
this order was updated?
Yeah,
I updated
Yes.
it based on, all right, I'll take that out. Okay, well, that takes care of that. Well, if you kick out that agenda, agreed agenda, let me know and I'll pass it on to Judge Williams.
Yeah, I mean, yeah, we'll do that. I mean, we just go full CMO and fill it in too if you want to do that, like we did in the other cases.
yeah, we can meet and confer on it, come up with something.
Like I said, it's more cases.
What else do we need to go over today? When are you going to start calling witnesses in Gallagher?
Probably, I would guess, September 12th. The jury selection takes a week.
When's the next trial?
On March's, actually.
Is that
January
February?
24th.
January 16th.
January 16th, I'm sorry.
Yeah. January 16th? In that R-I-C-H-T case, is there a plaintiff's counsel on that?
I don't think he's gonna get someone to pick up his case.
He's incarcerated right now?
Allegedly, he murdered his girlfriend. It's a real water rage. So we withdrew.
But it cures cancer, so already even.
Well, but there's no trial date in that case, is there, Joel? Right.
There is, it's currently April 24th.
So what we're doing is, we have a status check with Judge Kitchener tomorrow, and on Wardson, Henry, Richt, and the Cava case. The Cava case, we moved for a preferential trial date, but because of on Wardson on January 16th, we asked for a date after the Wardson trial in around March or so of 2024. Judge Kishner reads the preferential trial statute as mandating that the preferential trial be set within 120 days of the hearing on the motion without an ability to continue it, without first setting the trial date. So since we were asking for a March 2024 date, which is beyond 120 days, she denied the motion at that hearing and directed us to meet and confer regarding a schedule in Cava, and we're gonna have a status check with her tomorrow on setting the trial date in that case. We met and conferred on Friday. Our proposal is to set the Cava case, which has a person over the age of 70, on the current RIP date of April 24th, with all the same deadlines, and push the RIP case into June, where the Lisa King case is currently scheduled. So that's our position on the Cava case. So ideally, if Judge Kishner sets the Cava case on April 24th and moves the RIP case, so we're not, we're trying to limit our expert disclosures and the plaintiff depositions in the case that are actually going to be tried next in order. So that's why we pushed off the Martinez and Cheripov case, which is on the agenda. So we're not spending money on expert disclosures on cases that aren't up next for trial. So certainly Gallagher's up first. After Gallagher is Wardson, no question about that. And then after Wardson, we're hoping to try the Cava, Wren carriers right around that time too. We think those cases are appropriate for consolidation because it's all the 5 babies that really kind of let off the public health investigation. But that's our intent, is to line them up in that order.
All right, and the Wren case is the one that's February 5. Right.
That's February.
5.
That's right.
And so you have a status hearing on Judge Kishner tomorrow.
Yes.
And it's your request to switch those trial dates.
Yes, we think that setting the Cava case on April 24th should, is better priority because it involves the plaintiff who's over 70.
And I'm sorry, I missed, I was looking at my notes. And what's the case, what's the trial you're trying to switch? You're trying to put Cava in place, in which case?
Rick.
Yeah.
And also, Floyd, part of our reasoning on some of these cases is we want to get certain groups of defendants who haven't had the opportunity to move up to the front of the line yet involved, because they are resistant to doing things that are involved. So the Cava case has some of those and Rick doesn't. So for example, it wouldn't really behoove anybody to try just a one-off real water home delivery case, because what's that going to prove? So it doesn't make a point, it doesn't involve another distributor or anything. So it's better to try to get cases with different distributors. Or different.
With the distributor is supposed to home deliver.
Right, with the new distributor.
Well, Judge Kishner kicks something in the order pretty fast, so I'll watch it. And then I'll watch it. Joel, you're my calendar for trying to work with Eric to get out an agenda on the Hunter case.
Yeah, I've got a homework list so far, a bunch of things. We pretty much reached an agreement on Cava. And there's going to be a case management order, I think, submitted on Cava. address the expert disclosure deadline. So I think that's the only issue in how that we're going to deviate from.
Well, somehow I lost your agenda. I had the two agendas here. It was on that agenda.
Yeah, that's the first item.
That's what I thought. It's KAUBA.
KBEH.
KABEA.
Martinez and Sheriff.
Right. Well, that's what I was asking about Martinez earlier. What is the status of Martinez?
So we agreed to continue the dates in Martinez and Sheriff because both of those are just real water home delivery dates. The only issue is everybody agreed to the proposed continuance to June, except Hanna Instruments. They made some demands about dates between the expert disclosure deadlines that are contrary to everything else we've agreed to. And so just to be able to submit the stipulation on that, we added it to the agenda to say, hey, can we go with the normal 30 days that have been standard in all the cases, which it's unlikely we'll ever be dealing with these two cases, but if they do, experts will have been disclosed over and over and over again by then. So we just think it should be the standard schedule.
What's your proposal for Martinez and Sheriff?
I think we put just a June discovery cutoff date and 90 days back from that, initial disclosures, 30 days after that, rebuttal disclosures.
Do we have a trial date in either one of those?
Well, we do, but we're continuing. So as part of the stipulation, continuing the trial date. They're on the same stack as the Wren carrier, February 5th.
Well, if you can't work out the stipulation, send me the two proposals and I'll put one together. And that's just for Martinez and Sheriff, right?
Yes.
Who's here for Hanna Instruments?
Scott's on there.
Right here, Floyd.
Oh,
Can you state your name?
Scott Rasmussen.
Yeah.
If you two can't work out a schedule for those two cases, then each of you send me your proposed schedule and I'll put one out.
Sounds good. Scott Rasmussen speaking.
Thank you. All right, what else do I need to do? About Dr. Dara.
Yeah, they gave us 2 dates. We haven't had a chance they just give it to us today, I think. I believe it's the 25th, 27th of August.
21st and 23rd.
Whatever it was. We haven't had a chance to look at our schedules on that.
Oh,
They've given us 2 dates, so I'm thinking that's going to be worked out.
and that's the depot that I authorized an additional 2 hours.
2 hours.
Well, you don't need my approval to pick the date.
No, they just came up with dates this morning. Or at least I found out of it this morning on Wren.
All right, is there anything else I need to cover today?
I can't hear you, I'm sorry.
I'll pull up the other agenda. There was an agenda from Colt Dodrill. Just make sure that we did not.
I have that open if you want.
Yeah, Colt, can you tell us what's on your agenda?
Sure. Status regarding recently coordinated real water cases. I think we went over that.
Just a minute, Colt, somehow I ended up with your letters on the fact sheets, but I can't find your agenda.
It's kind of chewed up.
I mean, it came in Friday, right?
I believe that's right.
I show it came in Thursday at 10:14 a.m.
Who's talking?
This is Jim Cavanaugh.
Who determined Kavanaugh was the one going to be on the giant screen?
Jim, I'm showing mine July 28th at 1:55 p.m. So
All right.
Does somebody have it?
I can pull Friday out.
I've got my notes on it. Oh, this is what I'm doing. He asked for a status on recently coordinated real water cases. I wasn't sure what you meant by that.
Well, you had mentioned the, I'm going to pronounce it wrong, the Angula case. I didn't know if there were others. My next bullet point talks about real water cases that may not be coordinated or may not be coordinated yet. I understand there's been several that have been filed maybe in the last couple of months. I'm always trying to keep track to see if there's additional ones that may be joining our client or that may maybe be coordinated with this matter. And I thought Plaintiffs' Counsel could give us an update. I think we heard a little bit at this morning's hearing regarding the Blaine Jones case.
Yeah, we have not filed any new cases since we filed Consiglia. So Consiglia is the one with Blaine Jones. So on Consiglia, as I understand, Hanna and Waukeeta filed answers. Real Water is not accepted service, so we're going to go serve whoever we serve when they don't accept service. And that's the status of that case. With regards to the bankruptcy stay, as I understand it, the trustee is refusing to stipulate to lift the stay for Blaine Jones. So, but I'm not his attorney, so I just hear that secondhand.
Is that case going to get coordinated with these, or is that being taken care of separately?
That case to get coordinated, but I mean, first we have to effectuate service, and then they have to solve the bankruptcy problem. So I don't see that case really getting on the radar for a while.
Thank you.
And I was lost on this. The Nevada Beverage subpoena in the Henry case, what's the status of that?
Yeah, Plaintiffs' Counsel had subpoenaed SNAP benefits from a number of plaintiffs. And if I get the names wrong, I apologize. I think I saw one in Bordenave and Brandy Wren. I did not see any with Taquante Henry. So we went ahead and subpoenaed one. They need either an order from the court or an authorization. We reached out to Eric, and he had some questions on why we wanted 15 months, and we echoed the same time period that were requested by their office for their other plaintiffs. And I just thought, for consistency's sake, we get that going and use the same time frame for all plaintiffs.
This goes back to the whole redacted credit card stuff. We're not authorizing them to have unfettered access to all the plaintiffs' irrelevant purchase histories. And we've subpoenaed the documents to the extent that there's potential evidence of proof of purchase of real water. We'll disclose any of those records that are limited in scope and properly protecting the personal irrelevant information of our clients. But with Henry, there's no, I don't think that he purchased any real water through any benefits that he had. So there's no relevance to any of those documents.
Yeah, our understanding from his fact sheet, and I'd spoken with Ms. Switzler on this, is that he indicated he made purchases through SNAP. So we've not seen proof of any purchase, and we wanted to obtain that to see if he actually consumed retail water. I don't believe he's an HOD subscriber.
He consumed real water, but we'll disclose any proof of purchase that's available. So I don't know why they want to subpoena 15 months worth of records to find proof of purchase. I think it'd be in their interest if it doesn't exist.
What do you want me to do on this? You want to go through the subpoena process, or Eric, are you saying your client has advised you there are no other records on that, or no other purchases there?
I don't know for certain. I'm not aware of any purchases through his account. To the extent there are, we'll request them and provide proof of purchase of real water. But that's separate and apart from what he's asking for, which is to just get a blanket authorization for them to request everything that he's bought for 15 months using a benefits card. That is, we believe, overbroad, irrelevant, and not proportional to the needs of the case.
All right, well, would you send me a letter and I'll issue a ruling on that? I don't think we need a hearing. So, I don't know, within the next week or so, send me a ruling on that.
I think there's probably about 5 plaintiffs affected by this SNAP decision. These 3 I know.
5 plaintiffs total.
Yeah.
We can't work that out?
Well, the issue is whether or not we go get it first from SNAP and give it to them, or they just get to go and get everything that SNAP gives them. That's really.
Well, I would prefer you to go to SNAP, get what you can get, produce it to Colt and see if he's satisfied with it.
Yeah, well, SNAP's not too overly cooperative with us either, so that's why.
Well, it's really a 2-step process, because we could go to SNAP and get all the records, but all it is places of purchase. It's not, it's not going to say real water on there. So it takes them telling us, this is where I bought real water, and us getting the records and submitting it to the defendants to say, hey, they're saying they bought real water on these stores. Here are the entries of the proof of purchase of these stores on different dates. Then they go look up in their system what, the receipt codes or the data that they have underlying it, and then produce that data, and it shows, okay, real water was purchased on these stores or this many occasions. So that's what we've been doing in every case, and that's what we intend to do in all these SNAP benefits cases.
I think the thing that's even more problematic, because most of the SNAP retailers are not the more sophisticated retailers like Whole Foods and Costco. Most of them are these little convenience stores and remote locations that don't have the greatest records in the world.
Well, have you had your client, these 5 plaintiffs, have they advised you if they made purchases at SNAP? I mean, do we have something at issue here or not? That's what I'm trying to catch up on.
I don't think there's anything at issue. We're not withholding anything from them. We're just going through the steps to find any evidence, potential evidence of proof of purchase, and we'll provide that to them as we get it.
But did these 5 plaintiffs purchase at SNAP?
With SNAP.
With SNAP, yes.
Well, it's hard because they're saying this is years ago. For example, I know Bornoff a little bit better. She purchased at Albertsons. And so she said, I bought real water regularly at Albertsons. This is the one I would go to. I would buy it before work. It's bred by my work. And she said, well, I think I used my SNAP benefits, or here's this card, here's that card. We're in the process of hunting down every one of those to say, all right, give us the records related to this card, give us the records related to the benefits. To the extent that those records exist and show Albertsons, we'll disclose those to Albertsons and let Albertsons look at those entries and pull up the data that may underlie those purchases. So that's the process, and we're going through that process now. But, a lot of them say, well, I purchased at this store, and then we get the credit cards, and, it may be an old credit card they used, or, there's those types of issues that do come up, so I can't say anything with 100% certainty. All I can say is we are going through the steps to find any potential proof of purchase that we can. We're disclosing all that information. We think that's obviously relevant and proportional to the needs of the case, but going beyond those to get every single SNAP purchase history for 15 months, all that's going to, they're not even going to know where the real water purchases were, or what may involve a retail.
Yeah, Colt, that's not gonna list what the purchases were, is it?
Well, going to start with the fact sheet. He says he made, actually, I'll start with the complaint. His original complaint said he made purchases at 7-Eleven and Circle K. And then after we produced our list of retailers, Henry, and I'm talking about Henry specifically, Henry amended his complaint and said, no, I bought it, and I can't even remember where he's at, but he mentioned 2 specific retailers. So right now I've got no credit card, no payment anywhere document saying that he made purchases at any retailer. Everyone else says, here's some redacted cards. And I know you and I talked about that in another context, but Henry had amended his complaint and said he purchased at 2 retailers, one of which my client distributed to, and he hasn't produced any evidence. On Bordunov, plaintiff's office already subpoenaed the SNAP benefits. I don't need that. They've subpoenaed it and produced it. But on Henry, that he's saying he bought it at Terrible Herbst, which I distributed to, and AB Market, which allegedly purchased it from Costco. And I've seen, and on his fact sheet, he says he made purchases with his SNAP benefits card. I've not seen any of that. Right now, there's absolutely no evidence that he purchased any real water. Plaintiff's got the burden of proof, and they either got to prove it or we can deal with it with the court. And I'm trying to address it from a discovery standpoint. When I talked to Brianna, who is on this Zoom, she said she'd follow up whether that was an oversight that they missed a subpoena going out on Henry. And then I said, well, if you don't have it, I'll go ahead and subpoena it. So I did. There was no objection to the subpoena. And so I can either get an order from you in terms of a motion to compel plaintiffs to sign the authorization, or go through a motion to compel process with you to get the state. We've been in contact with someone from the AG's office that represents them to get an order from the court so that they're legally allowed to produce the requested information. If the issue is 4 months versus 15 months, we can hash that out. I was just using 15 months because that's what Kemp's office used on the Bordunov subpoenas. So I'm just trying to be consistent. I don't care. There's no purchase information, and the places where he's alleged to have purchased it are parties in this case, so we can get that purchase information or at least ask. But right now there's absolutely nothing but his medical records, which indicate he consumed something else.
There is his testimony, which is evidence.
Did you or Eric say that you had subpoenaed the SNAP?
In the Henry case.
No, but in another case, you subpoenaed
I think we have.
for the SNAP benefits? Well, why don't I give you the first shot of doing it in this case? If you can't get it done, I'll have like Colt do it.
We're gonna be doing it. Maybe if there's any other case besides Henry, and I know we're doing it.
We subpoenaed him in Bordunov.
If they have a list of cases they wanted us to do it in, it'd be best to keep it to us now with them all at the same time.
Colt, is there more than one case you want to get those?
Yeah, Floyd, as far as I know, that's the only one. I am not in all the cases. I think I'm only in 7 of these things. So that's the only one that I'm missing SNAP benefits from, as far as I know.
Referring to Henry, right?
Yeah, Taquante Henry is the one I'm missing.
All right, can you get the records for Henry?
Yeah, we'll do that.
All right, Colt, they're going to try to get the records for Henry.
Thank you.
I'm going to take it off my calendar. Let me know if we need to bring it back up. What else do we have? Anything? What do you need?
It's on Colt's letter, but it's an issue that's worth addressing, the applicability of the administrative order deposition behavior 48 cases. This came about as Judge Williams commented and asked the parties, and I don't know if there was a decision on it, whether or not the parties are bound by this, or Judge Williams as the judge in charge of this case, makes the rules, and the chief judge makes the rules, a comment to that effect. And obviously, we have no stake in that fight. We just don't know what the rules or what are.
Well, what's the dispute?
I think Judge Williams said he didn't consider himself bound by statements made in the Discovery Commissioner about what needs to be done or doesn't need to be done, such as producing documents that prove deposition. There's a lot of things in that Discovery Commissioner treatise. But he said he didn't consider himself bound by it.
He did consider
He did not consider himself bound by it.
The district court judges are above the discovery.
Yeah, so having him said that, I don't want to say that I consider myself bound by it if he's not bound by it.
Well, what's the dispute?
There is no dispute. They just put it on the agenda.
I just wanted some clarification, Floyd. We've got a lot of depositions going on other cases, and I wanted to make sure we had some consistency so we could have some predictability as we prepared for depositions in the remaining cases.
Well, the judges are bound, but I don't understand it. What is it you're worried about?
I just want to make sure I did not see anything in the CMO, and some of the drafts had included language that incorporated AO 2208. That language came out, but I don't see any language accepting these cases from AO 2208. And so I just wanted some clarification so we can proceed with the understanding as to whether it applies or it doesn't.
I don't think it applies because this is under complex litigation rules, which is why I think the judge felt the same thing. But I need to know what is it part of that administrative order that you're worried about?
I think specifically is what Mr. Kemp mentioned, which was production of documents prior to using them as exhibits at the deposition.
Yeah, the order says you're supposed to produce the document.
Right, anything you're going to use.
That, we do our best to, especially in the case of the experts, we press out exhibit sets to the opposing counsel. But we haven't been producing it to all the parties in the case.
You really can't.
I don't know if you can, and so I haven't heard of it being a specific problem in any deposition. There seems to be a lot of exhibits being used over and over and over again.
Some of them would be under the protective order.
Right.
Because you don't shoot it out to every turn of the case.
Yeah,
But if you use, well, I'd say use it to opposing counsel in that case, for that deposition. I'm not going to issue a formal ruling, I'll take care of it. The only problem is if something comes up that somebody wasn't prepared for, I may be forced to require the opponent to show up a second time.
Yeah, there haven't been a lot of surprise documents. At least I haven't seen a problem.
So try to avoid it. If there is a dispute, I'll rule on whether the party has to show up for a limited second deposition. When do we need to meet again? 3 weeks? 4 weeks? You guys are going to be pretty busy with Gallagher.
The last thing on Colt's letter was whether or not we need an ESI protocol.
Well, we've gone through the ESI. Colt, I thought you thought we were missing some terms.
No, it's my understanding that the proposals for ESI in the proposed CMO came out.
Was deleted.
Yeah,
So again, there's some ambiguity. We thought we could get some clarification as these issues come up in other cases.
I get kind of concerned about talking about this now because we spent Wednesday and Thursday arguing a motion to strike UNFI's answer. And during the hearing, we talked about ESI, EIS, ESI.
Yes.
Yeah, so I don't know if this proposal coming up following business day is designed to undercut any argument made there or enhance it. I don't know, but it hasn't been a problem yet, so I don't know why we need to go into it now.
Well, I haven't given a proposal.
Right.
Usually I get a proposal for electronically stored information, and then the attorneys put together an agreed list of key terms and a non-agreed list of key terms. We've never had to do that in any of this. Somebody wants to submit an ESI proposal and open that can of worms, go ahead.
Thank you.
It appears Mr. Parker thinks we're done, and he usually has a pretty good idea of these things.
Joe said there's only 2 more things to cover, and I think we've done 2 more, so.
Just one more thing. I show that we've covered everything on the agenda. I have a follow-up with Mr. Hale on Wren, he's welcome to stay on the record or not, but I'll just say with this. So we have a status check for Judge Eller on August 2nd, so I was hoping we could do a call with Plaintiffs' Counsel for August 2nd at 10 a.m. That's when the status check is. We got tomorrow off from Judge Floyd, so tomorrow morning off.
Well, as I recall, his email said he was available August 2 and 3. That was like the only thing.
Yeah, and we have to be, well, I don't mind doing an 8 or 9 a.m. call on August 2. We're going from the judge at 10 a.m.
All right, I'll set it up at 8:30. I'll shoot out an email to both. We'll do it at 8:30 on the 2nd.
Sounds good. Scott Rasmussen. What? I missed what case that was. Sorry.
ARAMBULA, unfair trade practices. The attorney wasn't available today, and he wanted to do it on August 2 or 3, and this was already set up. I didn't want to move it for all the attorneys, so I sent him an email this morning telling him I would set up a separate telephone call with him and with Joel.
Thank you.
Moving over to that part.
There was a federal class action case at the time, it was a state class action case at the time. This federal one just been dismissed.
Same one's left.
State one's left.
Oh, Floyd, if I understand on that 8/2/23 at 8:30 a.m. call, you will send out a notice to everyone? Scott Rasmussen.
Oh, I think it should. I was just going to get the new attorney and Joel on the phone. Are you involved in that one, Scott?
Most likely I will be.
Well, I think
I'll call you later. I don't think you will be. I'd be happy to explain my thought process.
Okay, and it's just because, as you know, Joel, I'm sort of involved in many of them, unless the plaintiffs have wised up and realized I'm not worth pursuing.
That's on the record, so we got it.
all right, how soon do I need to get everyone back together? 3 weeks, 4 weeks?
Yeah, I would think that we should do it before start the Gallagher trial. We start on
You said the 13th?
The 5th.
the 5th we start, but we do jury selection. Maybe Thursday before the 3-day weekend, Thursday before the 3-day weekend.
Meeting the end of August? All right.
The only reason I say that is there might be some issue on the expert file disclosures. So the expert disclosures on the
It'll probably be 3 weeks or so.
right.
All right.
Thanks, sir.
Thanks, everyone. For those of you on the Zoom, I think everyone's mic is muted. 100%. Does anyone on the Zoom have anything you need to add before I cut you off?
If I have a question, have you not ever seen that administrative order that was referred to today? It was Administrative Order 22-08.
Right.
Filed by the Chief Judge Bell before she moved on. It was filed May 9, 2022. Signed by the Discovery folks, but that's who signed the order. Did you want to get a copy of that, or?
Oh, I'm going to wait for the dispute, if any.
All right.
I've got the administrative order, so I can pull it up.
All right, thank you.
Thanks, everyone.
Thank you.
Thanks, Floyd.